The report is an alternative report to the UN Human Rights Committee that monitors the implementation of the international civil and political rights, which Kenya is a signatory to. It ratified the covenant, international covenant on civil and political rights in 1966. So it's we have every 4 years we have an obligation as a country to go and report in terms of how we are achieving or realizing or protecting and promoting the rights contained therein in the International Covenant on Civil and Political Rights. And of course those rights, most of them are in the Constitution of Kenya between Article 19 and Article 59. These rights include the freedom of expression, a right to life, freedom from torture, freedom from discrimination, freedom of expression, freedom of association, freedom of movement, rights of refugees and asylum seekers, and such kinds of rights. So what we were doing here today is to launch an alternative report to what the government has written, which necessarily does not mean it's a totally different report from what the government has written. It's a report by civil society institutions, a coalition of about 12 civil society organizations, where we will go this evening to Geneva and present this report for the next 12 days. There is a long hearing for many countries, but Kenya also is one of those countries listed for review. So in this review, what we'll be reviewing is not only the recommendations which arose from the last review in 2010, but also, 2008, but also the issues which pertain to the matters which have come full circle, especially after the promulgation of the new constitution. We find that there are areas where we have made a lot of progress, but there are areas which I think we need to make more concerted efforts to ensure that the rights contained in the International Covenant on Civil and Political Rights are protected and respected by the government and the society. Swali nyingine. We as a Kenya Human Rights Commission support what the judges said for only one reason. The Constitution is crystal clear. In Article 6, the Constitution is crystal clear that the national government and the county government shall conduct their mutual relations through consultation and cooperation. And the two governments are interdependent but distinct. And therefore, for us, when the case was taken to court, we were very happy with the outcome of the court, that not only did the appointment go without consultation between the President and the Prime Minister, but also the two-thirds gender principle was not met. Of course, you could, out of the 47 commissioners, most of them, majority were men, and therefore the two-thirds gender principle was not met. But equally a more serious argument, which was not taken to court, or we didn't ask the court, was about the constitutionality, even of the appointments. In my own view, it is unconstitutional for a national government to appoint county commissioners without consultation and cooperation of county governments, which will be led by governors. So those appointments, if they were to be made, they should have been made once we have county governments. And because we don't have them now, it is unconstitutional, courtesy of Article 6 of the Constitution. So I think the only thing that is happening is that we are in support of the Law Society of Kenya, that all those who have heard the law, when the judges issue an order, that is not an opinion, that is the law, and you follow the law. If there are people who are still in office in the counties, all of them should be taken to have to be contemptuous of the court order. And the court order, again, I repeat, is not an opinion of a judge or an email. That's a law. That once you're told to vacate office, you go back to where you were dispatched from. And most of them were dispatched from Nairobi. They should all come back here. I think the national government should look for alternative employment for these people until such a time when those appointments are done according to the Constitution and according to the law that will exist then, especially on devolved government law. And there must be consultation with the county governors, 47 of them. It cannot be business as usual. I think it's very high time that the President, and especially here the Attorney General, gave serious advice on how this country is run, because we must be a country that respects the rule of law. And when we break the law, somebody must come in, and I'm happy the judiciary came in defense, not only of the Constitution, but also of the Kenyan people. I will say it again. Kenyans, I think we have to read again Article 73 of the Constitution, or Chapter 6 in general, in terms of who is qualified to be a state officer. To vie for the presidency is vying for a state office. All these people will have to go through a vetting process. We must agree on, as a country, that there are people who somehow, through a vetting process, will not make it. So when the Minister of Justice says that Kenyans will decide, he is right in only one regard. Kenyans will decide once the names are on the ballot paper. But before any name or face of a presidential candidate or any other candidate is on the ballot paper, there is a team we shall constitute as a country. We shall have agreed on that, and we have agreed on it because Chapter 6 is existent, that will vet persons running for state office. All state officers, as you can see, members of the fourth state, and you broadcast this to us, everybody is vetted. You go through an application process, you bring a lot of paperwork, you bring a lot of certificates of HELB, of NSIS, of CID, of your degree, you bring it, a copy of your degree. You bring a lot of certificates to the public when you want to be publicly appointed. And it's a very rigorous process. It takes up about 6 months to be appointed to be a state officer. It should take the same process for any elected office. And that office of the president downwards up to the county assembly member. These are state officers according to Article 260 of the Constitution. And therefore, in my own take, I will put it this way. When you look at the crimes these people have been accused of, they are not suspected of, they are now accused. They are left with only two stages. Either they are convicted, like Thomas Lubanga was done this week, or Charles Taylor the last month, or they are free. So the question here is, it's very clear that it is difficult for these individuals to be even on the ballot paper. And if they are, and perhaps they win, if you read Article 141 of the Constitution, it says grounds for removal of the presidency by the Senate. One of the grounds is violation of international laws. And one of those international laws, for example, is the International Crimes Act of 2008. It's a Rome Statute, and there are 4 offenses in the Rome Statute: war crime, crimes against humanity, genocide, and crimes of aggression. So they have been accused of one of the crimes under international law. If they do, if somehow they sneak through into the ballot paper, I'm saying sneak, because maybe we will be asleep, and then we vote for them, there is ground for removal of these individuals because they've been accused by the world. This is not Kenyan accusing them. The world has decided these people there is high responsibility on their part for the crimes that occurred in Kenya. And these crimes are not ordinary crimes. These are international crimes. So the question before them is to prove their innocence. Agreed. But if they do decide to run, we will see. Because essentially, if they win, that is the ground for impeachment. And do you Kenyans want to elect someone and then impeach them in a month? Because really, between 10th and 11th of April, the trial could take, I don't know, maybe 2 years. These are questions which Kenyans have to agree. Kwani hakuna watu wengine wataweza kusimama rais? That's all.
Thank you.